Ladies and gentlemen, I welcome all to my channel. You are watching series of videos under the head Do's and Don'ts in Purchasing and Selling the Property. So far you have seen several important aspects. Now we are going to see one more important aspect, which is nothing but the registration of the sale agreement. Once you put in the previous video, I have discussed about the contents of the sale agreement. In this video, we are going to discuss whether registration of the sale agreement is advantageous to the buyer or it is advantageous to the seller. What are the consequences in the registration of the sale agreement? What are the risks in the registration of the sale agreement? What type of decision you have to take in selling the property? Which one is advisable? Registration is advisable or avoiding registration is advisable? How to handle the situation in selling or purchasing the property are all discussed in this video. If you ask me a question, whether it is advisable to registration, it is advisable to go for a registration or it is better to avoid such registration. The simplest answer is as per law. The law requires that you have to register the sale agreement as far as the Tamil Nadu is concerned. Once the sale agreement is made or executed and if it is not registered, then it will not have any validity. So the registration, unless it is registered, it will not have any validity or enforceability in the court of law. So as per law, you have to register a sale agreement. Now if you ask me a question about the advantageous position, the registration of the sale agreement is more advantageous one as far as the purchaser is concerned. Once the sale agreement is registered and supposing the seller get a better offer with another buyer, and if you go to the registrar office to sell the property to another buyer for a better price, the registrar will not permit him to register the sale deed. He will not permit to sell the property to another person. The registrar will say that the sale agreement is registered with respect to particular person, and during the subsistence of this sale agreement, you cannot register the sale deed in favor of another person. So if you want to go for a sale with another person, you bring the previous buyer and cancel the sale agreement, then only I will permit you to register sale deed with another person, like what the registrar will say. So as far as the purchaser is concerned, once you register a sale agreement, it will help you to secure your interest. It will also restrain the seller from selling the property to another person. So this is advantageous to the buyer. On the other hand, supposing the buyer did not come forward, supposing the buyer paid a nominal advance and registered a sale agreement and he did not come forward to complete the sale. In that case, in such situation, the seller's position will be somewhat pitiable one. In such circumstances, if another buyer came to purchase the property, and if you the seller went to a register office to sell the property to another person, the registrar will not permit him to register sale deed or to transfer the property to another person. So we will have to face consequences. In that case, if you ask the previous agreement holder to come and execute a sale, cancel the sale agreement, he may not come forward or he may demand some money. In that case, you will have to satisfy the requirements of the previous agreement holder. So you will have to face a lot of some sort of difficulties in such situation. So as far as the buyer is concerned, it is an advantageous one, and as far as the seller is concerned, there is a risk. So it is better, as far as seller is concerned, it is better to avoid to go for a registration of the sale agreement. You can directly insist the buyer to execute the sale deed directly without going for a sale agreement. The law does not stipulate that for every transaction, the sale, every party should make and execute a sale agreement. Law did not stipulate. The law only stipulates that once the sale agreement is made or executed, it is to be registered. The law only put a stipulation condition for the registration. The law does not insist the parties to go for a sale agreement. So as far as the law is concerned, the law does not stipulate that every party should execute a sale agreement for before every sale deed or for every transfer of a property. But law only stipulates that in the event of execution of the sale agreement, it should be registered, like what the law stipulates. So as far as the seller is concerned, if it is so possible, you can avoid the execution or registration of the sale agreement. On the other hand, suppose the party so insists you to go for a registration of the sale agreement, then in that case, at least you can put a specific clause saying that this agreement shall be valid only for a period of 3 months, and the buyer should deposit the amount with balance sale price within the 3 months period, and the buyer should complete the sale transaction within the period of the 3 months. In the event of the failure to complete the sale, or in the event of the failure to pay the balance sale price within the stipulated period, this agreement shall be cancelled automatically. The time is the essence of the contract. This agreement will automatically expire on the expiry of the 3 months period. Like what, you can put a specific condition. If such type of specific conditions is put, in that case you can tell the registrar saying that this agreement is valid only for 3 months and it is automatically cancelled on the expiry of such 3 months period, and I am entitled to sell the property to subsequent buyers after the expiry of that particular period. Like what, you can convey the sub-registrar and go for a sale of the property to subsequent purchasers and secure the interest. So this is the legal consequences behind the registration of the sale agreement. If you ask me what is the best source as far as which is beneficial to both buyer and seller, I don't have the answer. You have to it is to be decided on the case-to-case basis. If the buyer is genuine buyer, and if it is really required, and if your circumstances also required that you have to complete the sale, so all the decisions with respect to the registration of the sale agreement has to be taken on the basis of the case-to-case basis. The events applicable to case-to-case basis. So you cannot give a general rule. So depending upon you can consult your lawyer, you can consult your family members, and you can verify the genuineness of the parties, character of the parties, and after seeing all the things, you can decide whether it is better to go for registration or not. So this is the information I want to convey through these videos. And if you ask me a question about how to cancel the sale agreement, it's a different topic. It will be a lengthy subject. That subject I will cover in the next video. So ladies and gentlemen, you can watch my videos in my two YouTube channels. Raziak Sattamariom is a Tamil channel. Raziak Law Tube is an English channel. And you may also watch all my videos which is available in my websites, Ali Associate Chennai. You can watch all my videos by clicking the learn playlists, and you can clear any of your doubts through my videos, as so many videos are available in my channel and my website. In addition to that, if you have any specific doubt or clarification, you may also contact my cell number. If time so permits, I will give you necessary consultation and clarify your doubts depending upon my time and availability. I will come again with another topic. Until then, goodbye. Razia Kade.